Another black woman in my courtroom.
Judge Harold Graves didn't lift his head.
What a waste of everyone's morning.
Sir, I am the rightful owner.
You own nothing. You are nothing.
He looked at her, disgust twisting his face.
You people reek. The only reason someone like you sets foot in a rich neighborhood is to steal.
Someone chuckled.
Check her bag before she leaves.
Sir, I am innocent.
Shut your filthy mouth!
Graves slammed his gavel.
Dangerous, delusional. I want this closed before lunch. Record every charge.
No one spoke for her. Quinn Wells took out a small notebook, began writing violation by violation. He had no idea what she was writing would destroy everything he'd built in 22 years. 6 months before that courtroom, Quinn Wells had never heard of Ridgewood Estates. She was 34, Harvard Law, top of her class. 8 years at one of the most respected constitutional law firms in Washington, D.C. She had argued before federal courts dismantled discriminatory housing policies and published research that changed how 3 states handled racial profiling cases. Then she stopped. Not because she burned out, because she wanted to understand the machine from the inside. How courtrooms across America quietly crushed black defendants through procedure, not prejudice. On paper. She took a sabbatical, rented a small apartment, spent her mornings buried in court records from 12 different counties, tracking patterns that no one wanted to see. Quinn didn't look like a constitutional lawyer. She wore plain shirts, reading glasses from the pharmacy, and kept her natural hair pulled back. She spoke softly, listened more than she talked. People who met her assumed she was a teacher, maybe a librarian. That was fine with her. She'd learned long ago that being underestimated was the most powerful weapon a black woman could carry. The house in Ridgewood Estates was never supposed to be a statement. Quinn found it online. A 3-bedroom colonial at the end of a quiet street. Good bones. Reasonable price. She made an offer, paid in full, signed the deed. Everything legal. Everything documented. Ridgewood was the kind of neighborhood where every lawn was trimmed to the same height, where American flags hung from porches painted white every spring, where the Homeowners Association sent letters if your mailbox was the wrong shade of gray, and where, in 62 years, not a single black family had ever lived. Quinn moved in on a Tuesday. She wore jeans, an old college sweatshirt, and carried her own boxes. No moving truck, no help. Just her and a car full of books and case files. Margaret Ashford saw her from across the street. Ashford was 58, lived in Ridgewood for 31 years. She was the kind of woman who kept binoculars on her windowsill and called them bird-watching equipment. She watched Quinn carry a box to the front door, pull out a key, and walk inside. Ashford didn't call to welcome her. She called 911. "There's a black woman breaking into the Henderson house," she said. "She's carrying bags. Looks like she's looting the place." 2 patrol cars arrived in 4 minutes. They found Quinn in the kitchen, unpacking coffee mugs. "Ma'am, step away from the counter." "This is my house. I bought it. The deed is in that folder on the table." They didn't look at the folder. They looked at her. Handcuffs, front lawn, neighbors watching from their driveways. One teenager held up a phone, filming. Nobody said a word. Quinn didn't resist, didn't raise her voice. She stood on the lawn of the house she legally owned, hands cuffed behind her back, while Margaret Ashford watched from her window with her arms crossed. The case landed on Judge Harold Graves' desk 3 days later. Graves was 62. He had sat on the bench for 22 years. His father had been a judge. His grandfather had been a judge. The Graves family name was carved into the marble above the courthouse entrance. They had donated the building in 1961. To the public, Harold Graves was a pillar of the community. Tough on crime, respected by colleagues. He gave speeches at bar association dinners about the sacred duty of impartial justice. Behind the bench, the numbers told a different story. Over 22 years, Graves had convicted 94% of black defendants who appeared in his courtroom. The national average was 33%. He handed down sentences for black offenders that averaged 3 times longer than those for white defendants with identical charges. Nobody questioned it. Nobody filed a complaint. The prosecutors who worked his courtroom knew the rules. Bring a black defendant before Graves and you'd walk out with a conviction. Every time. His favorite prosecutor was Derek Stanton. 45, ambitious, sharp suits. The kind of man who smiled at you while preparing your indictment. Stanton had a 91% conviction rate in Graves' courtroom and a 46% rate everywhere else. They were a machine, and that machine had never lost. Until the morning a quiet black woman in a wrinkled shirt sat down at the defense table, opened a small notebook, and started writing. The courtroom smelled like old wood and floor polish. Fluorescent lights buzzed overhead, casting everything in a flat, institutional glow. Room 4B of the county courthouse. Graves' domain for 22 years. Quinn walked in at 8:47 a.m. She wore the same plain blouse from the arrest. No blazer, no briefcase. Just a thin folder in the notebook she carried everywhere. The gallery was half full. A few lawyers waiting for other cases. A court reporter adjusting her machine. 2 older women in the back row who came to courtrooms the way other people went to church, for the ritual of it. Derek Stanton was already seated at the prosecution table. Fresh suit, polished shoes. He arranged his papers with the calm precision of a man who had done this 1,000 times and lost almost none of them. He glanced at Quinn, then at the empty chair beside her. No lawyer. He almost smiled. Graves entered at exactly 9 o'clock. The bailiff called the room to order. Everyone stood. Everyone except Quinn. She was already writing in her notebook and stood a half-second late. Graves noticed. "The defendant will rise when this court is called to order," he said. "First warning." Quinn stood, said nothing. Graves settled into his chair, opened the file, and made a show of reading it. He already knew every word. He and Stanton had reviewed it the previous evening. But the performance mattered. The appearance of process. Quinn Wells, he read aloud. Criminal trespass, resisting arrest, disorderly conduct. He looked up. 3 charges, no legal representation. Is that correct? Your Honor, I would like to request a continuance to denied. The word came before she finished the sentence. Your Honor, under the 6th Amendment, I have the right to adequate time to prepare. You've had 3 days, Ms. Wells. That is more than adequate. He turned to Stanton. Proceed. Quinn's jaw tightened. She wrote in her notebook. Violation number 1. Denial of continuance without cause. Stanton stood and buttoned his jacket. He spoke to the gallery more than to the judge, a habit of men who enjoyed the sound of their own authority. Your Honor, on the afternoon of September 14th, the defendant was found inside a residence at 412 Maple Lane, Ridgewood Estates. The homeowner, the reporting party, observed the defendant entering the property without authorization and immediately contacted law enforcement. Objection, Quinn said. The reporting party is not the homeowner. I am. I have the deed. Ms. Wells, Graves' voice was a blade. You will not interrupt the prosecution. Sit down. Your Honor, I'm entitled to raise objections during I said sit down. The gavel hit the bench. The court reporter flinched. Quinn sat. Violation number 2. Denial of the right to object during prosecution's opening. Stanton continued without missing a beat. Officers arrived to find the defendant inside the property, handling items, moving through rooms. When asked to identify herself, the defendant became argumentative and, "That's not true," Quinn said quietly. Graves leaned forward. "Ms. Wells, I have warned you twice. One more outburst and I will hold you in contempt. Do you understand?" Quinn looked at him. Steady. Calm. "I understand, Your Honor." She wrote again. Violation number 3. Threat of contempt for exercising the right to respond. Stanton called his first witness. Todd Brennan walked to the stand like a man arriving at a job he'd done many times before. He was 41, stocky, with a buzz cut and a security company polo shirt. He'd been the neighborhood patrol officer for Ridgewood Estates for 6 years. "Mr. Brennan," Stanton began, "can you describe what you observed on September 14th? "Yes, sir. I was doing my regular patrol when I noticed an unfamiliar individual approaching the property at 412 Maple Lane. Black female, carrying bags. She entered through the front door." "Did she appear to have authorization?" "No, sir. The previous owners, the Hendersons, are white. I've never seen a black resident in Ridgewood." Quinn's pen stopped. She looked at Brennan. He didn't look back. "In your professional opinion as a security expert," Stanton said, "was the defendant's behavior consistent with criminal trespass?" "Absolutely. Classic pattern. Unfamiliar individual, carrying items, entering a property that doesn't match their—" He paused. "Their profile." "Thank you. No further questions." Graves nodded. "Defense, any questions for the witness?" Quinn stood. "Yes, Your Honor. Mr. Brennan, you referred to a classic pattern. Could you describe your training in criminal behavior analysis?" Brennan shifted. "I've been in security for 6 years. I asked about your training. Specifically, what certifications do you hold?" I completed a certification program through—" "Your Honor," Stanton interrupted. "The witness's credentials are well established." "Sustained," Graves said immediately. "Move on, Ms. Wells." Quinn stared at the judge. He had sustained an objection that hadn't even been properly formed. No legal basis cited. No argument heard. Violation number 4. She sat down and wrote. The morning ground on. Each time Quinn raised a point, Graves shut her down. Each time Stanton presented something questionable, Graves accepted it. The pattern was so precise, it almost looked choreographed. Because it was. At 10:15, Stanton introduced new evidence. Photographs from the neighborhood security cameras. They showed Quinn walking up the driveway, carrying a box, entering through the front door. "Your Honor," Stanton said, "the prosecution requests these images be entered as Exhibit C, demonstrating the defendant's unauthorized entry." "So entered," Graves said. "Your Honor," Quinn said, "those images show me entering my own home. I'd like to present the purchase deed." "The court has not asked for your documents, Ms. Wells." "But, Your Honor, the deed directly contradicts—" "I will not ask again." Graves pointed his gavel at her. "One more word, and you will spend tonight in a cell." The gallery murmured. A few people shook their heads, not at Graves, but at Quinn, as if she were the one causing trouble. A woman in the second row leaned to her husband. "Why doesn't she just get a lawyer?" A man behind her muttered, "Probably can't afford one." Quinn heard them. She kept writing. At 10:30, Graves called a recess. Quinn stayed at the defense table. She didn't move, didn't eat. She opened her notebook and counted. 11 violations in 90 minutes. Denial of continuance, denial of right to object, threat of contempt for speaking, improper sustaining of non-objection, refusal to accept defense evidence, witness testimony allowed without credential verification, prejudicial commentary from the bench, leading questions permitted without objection, evidence admitted without proper foundation, restriction of cross-examination, intimidation through threat of imprisonment. 11 in 90 minutes. She thought about her mother, Gloria Wells, a nurse in Detroit who worked double shifts for 23 years. In 2009, a patient's family accused her of theft, a missing watch worth $80. Gloria couldn't afford a lawyer. The court-appointed one met her for 6 minutes before trial. She was convicted in an afternoon, lost her nursing license, spent 11 months in county jail before the watch was found in the patient's own bedside drawer. No one apologized. No one gave those 11 months back. Quinn was 14 when her mother came home. She remembered the way Gloria sat on the edge of the bed, still wearing the clothes from processing, and said nothing for 3 hours. That was the day Quinn decided to become a lawyer. And now, sitting in a courtroom where the same machine was grinding her down, she understood something with absolute clarity. This wasn't about her house. This wasn't about Ridgewood. This was the system. The same one that ate her mother alive. She closed the notebook, placed her pen on top of it. When they come back from recess, she thought, I'll give them exactly what they expect. A quiet black woman with no lawyer and no chance. And then I'll show them what 20 years of preparation looks like. Quinn drove home in silence. No radio, no phone calls, just the hum of the engine and the weight of 11 violations sitting in the passenger seat like a second person. She pulled into the driveway of 412 Maple Lane, her house. The house the state of Georgia said she had broken into. She sat in the car for a full minute, hands on the steering wheel, staring at the front door. Then she went inside, set her keys on the counter, and called Thomas Aldridge. Aldridge was her former supervising partner at the firm in Washington. 15 years her senior, sharp mind. The kind of lawyer who could dismantle a federal regulation over lunch and still make his 2 o'clock tea time. Quinn, what the hell is going on? I saw the arrest report. I need you to listen. She told him everything. The arrest, the charges, Graves, Stanton, the fabricated testimony, the 11 violations. Aldridge was quiet for a long time. I'll fly down tomorrow, he said. I'll represent you. We'll file an emergency motion. Get this thrown out in a week. No. Quinn, if I bring a lawyer from a D.C. firm, Graves will play it safe. He'll follow procedure. He'll dot every I. And then he'll convict me anyway, quietly, and no one will ever know how he does it. So what are you going to do? Quinn looked at the notebook on the kitchen table, the pages she'd filled that morning. I'm going to let him show the world exactly who he is. She didn't sleep that night. By midnight, the living room of 412 Maple Lane looked like a war room. Court records covered the dining table. Stacks of case files she'd been collecting for her sabbatical research, now reorganized with a very different purpose. Quinn had spent 7 months studying judicial bias patterns across 12 counties in the Southeast. She had data on sentencing disparities, conviction rates, demographic breakdowns, all pulled from public court records, all cross-referenced, all documented. She hadn't planned to use it like this. The research was supposed to become a paper, maybe a book, an academic contribution to legal reform. Now, it was ammunition. She opened her laptop and pulled up the data on Judge Harold Graves. The numbers were staggering. In 22 years, Graves had presided over 4,136 criminal cases involving black defendants. He convicted 3,888 of them, 94%. The state average for comparable charges was 33%. His sentencing patterns were worse. Black defendants received an average of 4.2 years for offenses that white defendants in his same courtroom received 1.1 years for. Identical charges, identical circumstances, 4 times the sentence. Quinn printed every page, highlighted every anomaly, cross-referenced every case number. Then she moved to Derek Stanton. Stanton's conviction rate in Graves' courtroom was 91%. In every other courtroom in the county, it dropped to 46%. The gap wasn't skill. The gap was Graves. Quinn built a timeline.
Stanton had used uncertified expert witnesses in at least 14 cases before Graves, all involving black defendants. In every case, the defense's objections to witness credentials had been overruled. In every case, the defendant was convicted. Todd Brennan's name appeared in 7 of those 14 cases. Quinn leaned back in her chair. The coffee on the desk had gone cold hours ago. The house was silent, except for the hum of the refrigerator and the occasional creak of the old floors settling. She wasn't angry anymore. Anger had burned through her that afternoon and left something colder, harder, more precise in its place. This was what she had trained for. Not a courtroom performance, not a dramatic speech. This was pattern recognition, the ability to see a system's fingerprints and trace them back to the hands that made them. The knock came at 7:15 the next morning. Quinn opened the door to find a young man in a rumpled suit holding a coffee and looking like he hadn't slept either. "Ms. Wells, I'm Nathan Brooks. I'm a public defender with the county. I was in the courtroom yesterday." Quinn studied him. 28, white, earnest eyes. The kind of face that still believed the system could be fixed from the inside. "I know who you are," she said. "You were in the 3rd row. Left side." He blinked. "You noticed me?" "I notice everything in a courtroom, Mr. Brooks." She didn't invite him in. Not yet. "Why are you here?" Nathan shifted his weight. "Because what I saw yesterday was wrong. I've been a public defender for 2 years. I've watched Graves do this before. Not this bad, but the same pattern. Deny motions, allow garbage testimony, steamroll defendants who can't fight back." "And you've done what about it?" The question landed like a slap. Nathan looked at the ground. "Nothing," he said. "I filed 2 complaints. They went nowhere. I didn't have evidence, just observations." Quinn opened the door wider. "Come in." They sat at the kitchen table, the one covered in court records and highlighted printouts. Nathan stared at the papers like a man seeing a city from the air for the first time. "You've been researching him?" he said. "For 7 months? This is all public record?" "Every page." Nathan set down his coffee. "I have something you don't." He pulled a folder from his bag. 6 cases, black defendants, all convicted by Graves in the last 3 years. I represented 2 of them. The other 4 I watched from the gallery. Same pattern every time. Uncertified witnesses denied motions, fabricated behavioral notes in the court record. Quinn took the folder, read the first page, then the second. By the third, her hands had stopped moving. "The court records don't match the transcripts," she said. "I know."
I noticed it 8 months ago, but couldn't prove it wasn't a clerical error. It's not a clerical error. Look. Quinn placed his files next to hers. The alterations follow the same pattern in every case. Behavioral notes added after the hearing. Same phrasing. Aggressive, uncooperative, showed signs of deception. Word for word. Nathan stared at the parallel documents. He's been fabricating records. He and Stanton both. And they've been doing it for years. The kitchen was quiet. Morning light came through the window and fell across the papers like a spotlight. Nathan looked at Quinn. What do you need from me? The Judicial Conduct Commission. You said you filed complaints before. They went nowhere. Because you didn't have evidence. Now you do. She tapped the stack of printouts. But I can't file. I'm the defendant. It has to come from an officer of the court. You want me to file while the trial is still going? I want you to file and ask them to send an observer to the next hearing. Let them see it for themselves. Nathan picked up his coffee, took a long drink, set it down. When's the next hearing? Thursday. 2 days. I'll file today. Quinn nodded. She didn't thank him. She didn't need to. They both understood what they were walking into and what it would cost if they failed. She opened her notebook and turned to a clean page. At the top, she wrote 3 words: strategy, Thursday, everything. Tuesday night, Quinn and Nathan sat across from each other at the kitchen table, surrounded by paper. 2 laptops open, a printer humming in the corner, spitting out pages every few minutes. Nathan had brought everything his own. Case notes, transcripts from the 6 cases he'd flagged, and the original court filings he'd kept copies of against protocol. Show me the Henderson case again, Quinn said. Nathan slid the file across. Raymond Henderson, black, 31. Convicted of petty theft in Graves' courtroom 18 months ago. Stanton prosecuted. Brennan testified as the expert witness. Quinn placed the official court record next to the certified transcript, the word-for-word stenographic record of what was actually said during the hearing. Read line 47 of the transcript, she said. Nathan read aloud. Defendant remained seated and responded calmly to all questions. Now read the corresponding entry in the court record. Nathan's eyes moved to the other document. His voice slowed. Defendant displayed aggressive body language and refused to cooperate with court proceedings. He looked up. That's not even close. Keep going. They compared every page, every entry. The transcript, the objective word-for-word account recorded by the court reporter in real time, told one story. The official court record filed days later and signed by Graves told another. In the Henderson case alone, Quinn found 9 discrepancies. 9 moments where the court record directly contradicted what the transcript showed actually happened. Calm defendants described as hostile. Cooperation rewritten as defiance. Requests for counsel reframed as disruptions. This isn't bias, Nathan said. This is forgery. Federal forgery, Quinn said. Falsification of court records under 18 U.S.C. Section 1519. Up to 20 years. She pulled up her spreadsheet. 14 cases over 3 years. All black defendants. All prosecuted by Stanton. All decided by Graves. She had found discrepancies between transcripts and court records in every single one. The same phrases appeared over and over. Aggressive. Uncooperative. Showed signs of deception. copy-pasted from case to case like a template. "He's been using the same language," Nathan said, reading over her shoulder. "It's almost identical every time." "Because it is identical. He doesn't even bother to change the wording." He never expected anyone to compare these documents side by side. Quinn leaned back. The printer had stopped. The house was silent. "There's something else," she said. She opened a new file on her laptop, the one she hadn't shown Nathan yet. Todd Brennan, the expert witness who had testified against her. The same man who had testified in 7 of the 14 cases. His security certification expired 3 years ago, Quinn said. He renewed it once in 2019 through an online program that was shut down by the state board for fraud 6 months later. Every court appearance since then, including mine, he's testified under credentials that don't exist. Nathan stared at the screen. Stanton had to know. Of course he knew. He's the one who kept calling Brennan as a witness. And Graves is the one who kept sustaining objections every time a defense attorney tried to question Brennan's credentials. She closed the laptop, placed both hands flat on the table. Here's what we have. Falsified court records, federal crime. A fake expert witness used repeatedly. Prosecutorial misconduct. A judge who suppresses every challenge to the fraud. Judicial corruption. All documented, all cross-referenced, all provable. Nathan exhaled. And the commission? I filed the request this morning. Asked for an observer at Thursday's hearing. If they show up and see Graves do even one of these things live, it's over for him. Quinn didn't smile. She picked up her pen and opened the notebook to the strategy page. It's over for all of them. Thursday morning, 8:32 a.m. Quinn arrived at the courthouse 28 minutes early. She wore the same plain blouse, same glasses, same notebook tucked under her arm. Nothing about her appearance had changed. Everything underneath had. The courtroom was different today. Fuller. Nathan had made calls, quietly, carefully. 3 local attorneys sat in the gallery, 2 of whom had lost cases before Graves and never understood why. A reporter from the county paper sat in the back row with a notebook of her own. And in the second-to-last row, near the door, 2 people Quinn had never seen before sat with their hands folded. She didn't look at them, but she knew who they were. Nathan caught her eye from across the room. One small nod. The commission had sent observers. Graves entered at 9 sharp. Same routine, same authority. He settled into his chair and scanned the room, pausing briefly at the unfamiliar faces in the gallery. His eyes narrowed, then moved on. "Ms. Wells," he said, "I see you still haven't retained counsel." "I will be representing myself, Your Honor." "Of course you will." He turned to Stanton. "Let's finish this." Stanton stood, buttoned his jacket. "Your Honor, the prosecution calls Todd Brennan to the stand for continued testimony." Brennan walked up. Same polo shirt, same buzz cut. He placed his hand on the Bible, swore the oath, and sat down like a man punching a time clock. Stanton lobbed the first question. "Mr. Brennan, based on your professional experience, is it common for individuals engaged in criminal trespass to carry personal items, bags, boxes, to create the appearance of legitimate activity?" "Very common," Brennan said. "It's a known tactic." "And in your expert opinion, did the defendant's behavior on September 14th match this pattern?" 100%. Stanton nodded. "No further questions." He sat down without looking at Quinn. Graves turned to the defense table. "Ms. Wells, do you wish to cross-examine?" Quinn stood,
slowly. She picked up a single sheet of paper from her folder and walked toward the witness stand. Mr. Brennan, you've testified in this courtroom 7 times, is that correct? Brennan glanced at Stanton. Sounds about right. 7 times, Quinn repeated. And each time you were introduced as a security expert, correct? That's what I am. What certification do you currently hold? The courtroom was quiet. Brennan shifted in his seat. I completed a certified protection professional program. Through which institution? National Security Training Institute? Quinn looked at her paper. The National Security Training Institute was shut down by the State Licensing Board in January 2020 for fraudulent certification practices. Were you aware of that? Brennan's mouth opened, closed, opened again. That's not... Your certification was issued in November 2019. The program was invalidated 3 months later. Every credential it issued was revoked. She held up the paper. This is the State Board's revocation notice. Your name is on page 4. Stanton shot to his feet. Objection! The witness's credentials were already accepted by this court. On what basis? Quinn turned to face Stanton directly. Under Federal Rule of Evidence 702, expert testimony requires demonstrated knowledge, skill, experience, training, or education. Mr. Brennan holds none of these. His certification was issued by a fraudulent institution and revoked by the state. He is not an expert. He has never been an expert, and he has testified as one in this courtroom 7 times. The room went still. The court reporter's fingers hovered over her keys. Graves' face was red. Ms. Wells, you are out of order. I am exercising my right to challenge witness credentials, Your Honor. A right guaranteed under Daubert v. Merrill Dow Pharmaceuticals, 1993. Would you like me to cite the specific holding? Graves stared at her. His jaw worked. The gavel sat in his hand but didn't move. For the first time in 22 years, Harold Graves had no response. The gallery stirred. The attorneys in the 3rd row exchanged glances. The reporter was writing fast. And in the second-to-last row, one of the commission observers leaned to the other and said something too quiet for anyone to hear. Quinn wasn't finished. Mr. Brennan, one more question. She turned back to him. Who asked you to testify today? Brennan looked at Stanton. Stanton looked at the table. Mr. Brennan? The prosecutor's office contacted me. And who contacted you for the Henderson case in 2023? And the Williams case? And the Carter case? I don't remember the specifics. The same office. The same prosecutor. Brennan swallowed. Yes. Thank you. Quinn walked back to the defense table. She didn't sit down. She stood facing Graves and said, Your Honor, I move to strike all of Mr. Brennan's testimony from this proceeding and from every prior case in which he testified without valid credentials. Graves gripped the gavel. His knuckles were white. Motion denied, he said, but his voice cracked on the second word. Quinn sat down, opened her notebook, wrote 1 line. She didn't need the motion to be granted. She needed everyone in the room to hear it denied and to understand what that denial meant. The 2 observers in the back row were already on their phones. Graves called a recess at 10:04 a.m. He didn't give a reason. He stood, knocked his chair back with his knee, and disappeared through the door behind the bench without looking at anyone. The courtroom exhaled. Stanton stayed at the prosecution table. He didn't stand, didn't pack his papers. He sat perfectly still, staring at a spot on the wall, like a man recalculating every decision that had brought him to this chair. Brennan was still on the witness stand. Nobody had told him to leave. He sat there,
hands on his thighs, blinking under the fluorescent lights, until the bailiff finally said, "You can step down, sir." He walked out of the courtroom without looking back. In the hallway, the noise began. The 3 attorneys Nathan had invited were already talking in a tight circle near the water fountain. One of them, a woman named Patricia Holt, who had lost a case before Graves in 2021, was shaking her head slowly, over and over. 7 times, she said. He testified 7 times, and I never thought to check his credentials. None of us did. The reporter from the county paper was on her phone, speaking quickly. "Yes, I need to talk to the editor." "No, it can't wait. I'm at the courthouse. You're going to want to clear space for tomorrow." Nathan stood near the courtroom doors, watching the hallway fill with whispered conversations. He caught Quinn's eye through the glass. She was still at the defense table, still sitting, still writing. He walked back inside. "The commission observers," he said quietly, leaning across the bar. "They left during the recess, both of them." Quinn didn't look up. "They didn't leave. I saw them walk out. They went to make calls, Nathan. There's a difference." Behind the bench, in the private chambers that smelled like old leather and pipe tobacco, Harold Graves was pacing. He'd loosened his tie. His robe hung on the back of the door. The air conditioning hummed, but sweat still beaded along his hairline. 22 years. 22 years of running this courtroom like a machine. Every outcome controlled, every variable managed. Prosecutors who knew their role. Witnesses who said what they were told. Defense attorneys who were too overworked or too intimidated to push back. And now this. A woman with no lawyer, a notebook, and a single sheet of paper had unraveled his expert witness in 4 minutes. He picked up his phone and dialed Stanton's cell. "What the hell was that?" "Judge, I didn't know about the certification." "You didn't know? You've been using Brennan for 3 years. You put him on the stand 14 times, and you didn't know his credentials were revoked?" Silence on the other end. "Fix this," Graves said. "I don't care how. When we go back in there, I want new evidence. Something solid, something she can't touch." "Harold, maybe we should—" "Don't use my first name. And don't even think about suggesting we drop the charges. I am not losing to some woman who can't even afford a suit." He hung up, straightened his tie, put his robe back on. In the mirror by the door, he practiced the face he'd worn for 2 decades. Calm, authoritative, untouchable. The face of a man who had never lost control of his courtroom. But his hands were shaking, and the face in the mirror didn't believe him anymore. At 10:31, Graves returned to the bench. The courtroom had filled. Word had spread during the recess, the hallway conversations, the reporter's phone call, the attorneys texting colleagues. 15 more people had squeezed into the gallery, standing room only against the back wall. Graves scanned the crowd. His eyes stopped on the second-to-last row. The commission observers were back, seated, notebooks open. He looked at Quinn. She was exactly where he'd left her. Same posture, same notebook, same calm expression that he'd mistaken for weakness 3 days ago. For the first time, a thought he'd never had before crossed his mind. Who is this woman? Quinn looked up from her notebook. Their eyes met. She didn't blink, didn't look away, didn't smile. She turned to a new page and waited. Graves picked up his gavel. It felt heavier than it had that morning. "Court is back in session," he said. His voice was steady, but the room had changed. Everyone could feel it. The current had shifted. The tide had turned. And the man behind the bench was no longer the most powerful person in the room. Mr. Stanton, Graves said, does the prosecution have anything further? Stanton stood. He'd used the recess to regroup. New folder, new confidence, new angle. Your Honor, the prosecution would like to introduce additional evidence. Exhibit D, security camera footage from Ridgewood Estates captured on September 12th, 2 days before the arrest. He clicked a remote. A screen on the wall lit up. Grainy footage showed Quinn walking along the sidewalk in front of 412 Maple Lane, looking at the house, pausing at the driveway, then walking away. This footage, Stanton said, shows the defendant conducting surveillance of the property 48 hours before the alleged trespass. This is consistent with premeditated criminal behavior. The gallery murmured. Graves leaned back satisfied. This was the recovery. This was the new evidence he'd demanded. Quinn stood. Your Honor, I'd like to respond. Graves waved his hand. Make it quick. That footage shows me visiting the property with my real estate agent 2 days before closing. I was inspecting the house before finalizing the purchase. She opened her folder. I have here a signed statement from my agent, Carolyn Webb, confirming the appointment on September 12th at 2:15 p.m. I also have the final closing documents dated September 13th, the day before my arrest, showing full transfer of ownership. She held up the deed, the county seal, the notarized signature, the closing statement showing payment in full. I didn't break into that house, Your Honor. I bought it, legally, completely, and every document proving that has been available since the day I was arrested. Stanton's jaw tightened. He didn't sit down, but he had nothing to say. Quinn didn't stop. Your Honor, I'd now like to address the charges themselves. Graves' eyes narrowed. What about them? Criminal trespass requires unlawful entry into a property the defendant has no right to access. I own the property. The charge is legally baseless. She turned a page. Resisting arrest. The arresting officer's own body camera footage, which I obtained through a public records request, shows me standing still with my hands visible for the entire encounter. I did not resist. She placed the USB drive on the defense table. The footage is here. I'd like it entered into evidence. That won't be necessary, Graves began. Disorderly conduct. Quinn continued, her voice steady and clear, cutting through his objection like a scalpel. The statute requires conduct that causes public alarm or disruption. I was unpacking boxes in my kitchen, alone, with the door closed. She looked at Graves. Every charge against me was fabricated, and every person in this room now knows it. The courtroom was silent. Not the silence of boredom or routine, the silence of people holding their breath. Quinn reached into her folder and pulled out the last document, a thick stack bound with a black clip. Your Honor, I have one final matter. Graves shifted. The court doesn't have time for this will be brief. Quinn held up the stack. This is a statistical analysis of every criminal case heard in this courtroom over the past 22 years. All data was sourced from public court records. She opened the first page. In 22 years, this court has convicted 94% of black defendants. The state average for comparable charges is 33%. She turned the page. Black defendants in this courtroom receive sentences averaging 4.2 years. White defendants with identical charges receive 1.1 years. Same courtroom, same judge. Another page. The prosecution has used uncertified expert witnesses in at least 14 cases, all involving black defendants. In every case, Defense challenges to witness credentials were overruled by this court without legal basis. Another page. In 6 of those 14 cases, the official court record contains entries that directly contradict the certified transcript. Defendants described as aggressive in the record were documented as calm and cooperative in the transcript. These alterations were made after the hearings concluded. Quinn set the stack on the defense table.
The sound of paper hitting wood was the loudest thing in the room. "This is not a courtroom, Your Honor. This is a conviction factory. And the evidence, all of it public, all of it verifiable, proves that it has been operating as one for over 2 decades. Graves gripped the bench with both hands. His face was white. His mouth moved, but nothing came out. From the second to last row, a chair scraped against the floor. One of the commission observers stood, then the other. The first one, a tall woman in a gray suit, walked forward past the gallery, past the bar, and stopped 5 feet from the bench. She held up a badge. "Federal Judicial Conduct Commission." Her voice was flat, professional, final. "Judge Graves, this proceeding is suspended. You are hereby placed on immediate administrative leave pending a full investigation into judicial misconduct, evidence tampering, and systematic civil rights violations." Graves' gavel slipped from his hand. It hit the bench and rolled to the floor. Nobody picked it up. The courtroom didn't erupt, it unraveled. Graves stood behind the bench, both hands flat on the surface as if letting go would mean falling. 2 federal marshals entered through the side door. The commission observers had called them during the recess. They walked to the bench and stood on either side of him. "Judge Graves," the tall woman from the commission said, "please remove your robe and step down." Graves' mouth opened. "This is my courtroom. I've served this bench for 22... Sir, your robe." His hands fumbled at the zipper. The black fabric, the same fabric that had given him power for 2 decades, slid off his shoulders and pooled on the floor behind the bench. He stepped down. Not through the private door he'd always used, through the front, past the prosecution table, past the gallery. Past the people who had watched him rule this room for 22 years without ever being challenged. Nobody stood for him. Nobody looked away either. They watched. The door closed behind him. And just like that, Harold Graves was gone from room 4B for the last time. Stanton was next. He hadn't moved from the prosecution table. His folder was still open. His pen was still in his hand. He looked like a man sitting at a dinner table after the house had caught fire. The second commission observer, a man in his 50s with silver hair and a calm voice, approached him. "Mr. Stanton, we'll need you to surrender your case files for this proceeding and all related matters. You are suspended from practice effective immediately, pending an investigation into prosecutorial misconduct and conspiracy to falsify court records." Stanton set the pen down, carefully, like it was the last thing he'd ever do in a courtroom. "I want a lawyer," he said. The observer nodded. "That's your right." Stanton stood, buttoned his jacket, the same gesture he'd made 100 times before closing arguments, and walked out. The folders stayed on the table, open, unfinished. The commission officer turned to Quinn. "Ms. Wells, all charges against you are vacated. This court has no standing to proceed. You are free to go." Quinn nodded. She closed her notebook, placed her pen on top of it, gathered her folder. She didn't smile, didn't pump her fist, didn't say a word. She stood, turned to face the gallery, and walked toward the door. As she passed the 3rd row, Patricia Holt, the attorney who'd lost her case before Graves in 2021, reached out
and grabbed her hand. "Thank you," Holt whispered. Her eyes were wet. Quinn squeezed her hand once, then let go. In the weeks that followed, the machine Harold Graves had built for 22 years came apart, piece by piece.
The Federal Judicial Conduct Commission launched the full investigation.
Graves was permanently disbarred within 60 days. Criminal charges followed: falsification of court records, obstruction of justice, conspiracy to deprive citizens of civil rights under color of law. He faced up to 30 years. Stanton's license was revoked. His 14 cases with uncertified witnesses were flagged for review. 3 other prosecutors in the county resigned before the investigation reached them. Margaret Ashford received a civil lawsuit from Quinn's attorneys filed the day after the trial ended. Filing a false police report. Racial discrimination under the Fair Housing Act. Ashford settled out of court for an undisclosed amount. Sold her house in Ridgewood Estates and moved out of the county. No farewell party. No forwarding address. 38 cases from Graves' courtroom were reopened for review. 38 families who had been told that justice was served learned that it had been manufactured instead. 12 people were released. One of them was a man named James Whitfield, 43, convicted of aggravated assault 5 years earlier on testimony from Todd Brennan. He had maintained his innocence from the day of his arrest. Nobody believed him. He walked out of County Correctional on a Tuesday morning. His daughter was waiting in the parking lot. She was 11. She had been 6 the last time she saw her father, outside of a visitation room. James knelt on the asphalt. His daughter ran to him. He wrapped his arms around her and held on, like the ground might open up and take her away again. He didn't say anything for a long time. When he finally spoke, it was one sentence. "I'm never leaving you again." A reporter captured the moment. The photograph ran on the front page the next morning.
In the background, barely visible, a woman in a plain blouse and reading glasses walked toward the parking lot exit. Nobody recognized her. That was fine with Quinn. 3 months after the trial, Quinn Wells stood in a conference room on the 4th floor of a building she had rented with her own money. The sign on the door read, "The Wells Justice Initiative." Inside, 6 desks, 4 laptops, 2 interns from the local law school, and 1 full-time attorney, Nathan Brooks, who had resigned from the public defender's office the week Graves was disbarred. "You could have gone to any firm in the country," Quinn told him the day he showed up. "I could have," he said. "But those firms weren't in this room." The initiative's mission was simple. Free legal representation for people who had been wrongfully convicted, couldn't afford counsel, or had been crushed by a system that was supposed to protect them. In its first 90 days, the initiative took on 23 cases. 14 were from Graves' courtroom. The rest came from neighboring counties, people who heard the story and for the first time believed someone might actually listen. Quinn didn't do interviews, didn't write op-eds, didn't accept the 3 speaking invitations that arrived in her inbox every week. She worked. Case files in the morning, court appearances in the afternoon, research at night. The same notebook sat on her desk. She'd filled it during the trial and never replaced it. Sometimes, between cases, she'd flip back to the first page, the one she'd written in room 4B while Harold Graves watched her and smirked. 11 violations. That was where it started. 6 months later, Quinn was appointed as a federal consultant on judicial reform. She helped draft new oversight protocols for courtrooms in 9 states. Anonymous bias audits, mandatory credential verification for expert witnesses, real-time transcript matching to prevent record falsification. The reforms weren't perfect. No system ever is. But in the counties where they were implemented, wrongful conviction rates dropped by 31% in the first year. Quinn never moved out of 412 Maple Lane. She mowed her own lawn on Saturday mornings, wore the same reading glasses, waved at the neighbors, the new ones, who waved back. The house was quiet. The street was quiet. And for the first time in a long time, that quiet meant peace. If you were Quinn, would you have stayed silent or fought back? Drop your answer in the comments. And if you believe that everyone deserves a fair chance in a courtroom, share this story with someone who needs to hear it. Subscribe and hit the bell, because stories like this one shouldn't stay hidden. Hashtag Justice for Quinn. Hashtag Equal Justice. Hashtag Courtroom Drama. Hashtag Wells Justice Initiative.
And I'm going to be straight with you. The scariest thing in the world isn't a bad person. It's a bad system. Because a bad person can only hurt you once. But a bad system, it hurts people every day, for years, for decades. And Courtroom is justice. It wears a robe. It carries a gavel. It sits behind a bench and tells you this is how it's supposed to work. And most people believe it. Because who question the system? Who has the time? Who has the energy? Who has the proof? That's what they count on. They count on you being so tired, too broke, too scared, too alone. They count on nobody comparing the documents, nobody checking the credentials, nobody sitting in the back row with a notebook, writing down every single thing they do wrong. Because the moment somebody does that, the moment one person starts paying attention, the whole thing falls apart. But here's what I really want your own to hear. She didn't fight with anger. She fought with preparation. Years of it. Quiet. Invisible. Nobody knows your name preparation. And when the moment came, she didn't need to yell. She just opened the folder and the truth did the rest. So tell me, do you trust the system? Should you? Drop it in the comments. If this one got you, share it, like it, subscribe. Because justice shouldn't depend on whether somebody in the room is smart enough to catch the light. It should just be real.